questions here, and then I know people have places they need to be. We'll sort of go this way around the room. If there are any, go ahead. And can you just say your name and who you're with?
Yes. Linda Becerra with WNBC TV in New York. You mentioned the Protection of Lawful Commerce and Arms Act providing some immunity for the gun manufacturers. There are some exceptions, very few. Can you tell us what was used in this particular case?
Yes, that's an excellent question. So there were two exceptions we initially were filing the case under. The first is called negligent entrustment. And this goes back to what I was saying earlier, where when I learned about the gun and I learned actually what it was and what its use was, it was just instinctive. You don't have to be a lawyer to say, wait, why is this a combat weapon? Like, why is it reasonable to sell at all? Okay, I didn't understand it. It made no sense to me. And so, it's not a tight fit with the negligent entrustment law, because what usually negligent entrustment would be if you give your keys to a drunk driver, so it's more focused on the point of sale, so to speak. But my whole thought was it's just not suitable for the civilian population. And I was actually kind of thinking, how many shootings like Sandy Hook can we really tolerate before it's just clear that even though 99.9%, probably even more than that, of AR-15 owners, are maybe responsible, there's a tipping point where that minority of owners just that's the tail that has to wag the dog. So that's when we get to that tipping point. I don't know, but and in terms of the winning argument, so that argument didn't work. We tried it with the Supreme Court. That was my idea. It didn't work. Eleanor's idea did work, and that was that there's another exception called we typically refer to as a state predicate exception. Let me break it down. So basically, Congress was not willing to give, it was a thumb on the scale, but not a complete, stomping on the scale. They were not willing to let the gun industry off the hook for breaking a state law that was applicable to the sale or marketing of firearms. And so we argued successfully that the Connecticut Unfair Trade Practices Act, which is a marketing statute, applied to the gun industry, just like everybody else. They tried to argue that they also should have an exception for that because, I guess, applying to the sale or marketing or firearms, that didn't fit a statute like that, but we prevailed on that. So basically the takeaway here is if a gun industry breaks the law, whether it's a criminal or civil law, there can be accountability for the repercussions of that. In our case, it was the state law. It could be a federal law, a gun, selling of a fully automatic weapon, for example, that's used in the shooting. Though we recently were unsuccessful in bringing that case in relationship to the shooting at Las Vegas. Hi, Todd.
Did you seek, and is there in the settlement an admission of wrongdoing?
Well, I can't really get into that. I mean, there are certain limited confidentiality. I mean, the answer is I'm not sure I can get into it. But I would say that I would consider, without specifically answering the question, what I would say is the proof is in the pudding. You have 4 insurance companies. They're all represented by different people. They all paid their very last dollar. They were looking at the same, circumstances that we were. Remington's bankrupt, so they're out.
Mm-hmm. Secondly, can you comment on what the plan is to tell that story, in as much as that's basically what the families wanted most out of this, was to be able to pull back the curtain, as you said?
Right. Sure. On this, I probably can't answer the second question because I think I mentioned earlier that when you have a lot of documents, you still have to make it so that it's digestible and everything. So it's still a work in progress. On the first part, I wasn't. I had never handled a gun case, so and I wasn't really. I became aware that this was a place that people don't have much luck getting into, and so I just understand it through the eyes of other people, which is now understanding that you had this opportunity and we wanted to drive a truck through it because we knew, we don't know, we wanted to take the opportunity. And people talk about the tobacco case and the opioid case. There's lots of similarities in terms of, greed, excessive marketing, pushing opioids on drug-addicted people, pushing cigarettes on kids. And at least, a lot of cases that are the first of their kind do end up making meaningful change. So there was no chance this family was going to give up on the fight to do that in service to the greater good of this country.
Kate. Kate.
Hi.
Kate Snow with NBC News.
Hi, Kate.
Hi. What is, broadly, big picture, what is the significance of what we've done, this settlement? Do you think it will set precedent for other cases in the future?
Biggest picture, I think it remains to be seen, but in terms of, I would say that I think it's a roadmap of some kinds. It's like that crack in the door, use your analogy, and that's what the law is built on, like series of steps. Somebody has to crack the door and get lucky or just, the right case or something. And in terms of the impact, I mean, I think that I'm putting myself in the shoes of an insurance company right now, actually. Like, it's over. It's over. You're not invincible. And the best way that this could be resolved is if instead of filing lawsuits for grieving and shattered families, the industry could just act like regular, responsible people, right? So that's what I hope. I hope the settlement does that.
Have you done something that no one else has been able to do?
I don't know. Well, I mean, I think I would say that this case has gotten further than anybody, I think, gave us credit it would ever go. I actually kind of knew we were in good shape when all the experts came out and said this case doesn't have a chance, because people are always not comfortable with saying that there was something new, there was precedent, but if there was never anything new, there'd never be precedent set, right? And they didn't see what Alan and our team saw when we launched this case. And I actually kind of can't blame them, because if somebody asked me about some other person's case like this, I would have said, good luck with that.
Last question on the side.
Hi, Napa with WPRI.
Hi.
This has been a very, obviously, long battle for these families. With the offer to settle last summer, what was the tipping point? What changed to actually get us to this point today?
Right. Well, at the time of that public offer, we were still trying to accumulate information, right? So there were two things about that public offer that were inadequate. First of all, it only represented two of the insurance companies. So we felt that for this case to have the impact it should, that all four insurance companies need to feel, I was going to say feel the pain, but how is pain even relevant to that with this? But you get the picture, like they had to all be on board, because it wasn't, as a purely compensation thing, it wasn't nearly enough for what happened, right? But it was important that to send the message, I think, that you need to you're uninsurable or you need to get a lot more of insurance, because that's the kind of harm that can come from this. The second thing, your second point of your question is really also important, which is at that time, that was several months, 6 months ago or something like that, maybe longer. We were still taking depositions. We were still trying to get the documents that we promised these families. And so it was pretty much an easy decision. It was a sign that there was an interest, at least, but it was a very easy decision for us to say, no documents, no deal.